But yes, Randy Adler.
Thank you. Chairman, members, my name is Randy Adler, and I'm an attorney out of Dallas, Texas. And I've been practicing law for 40 years, and I've had the pleasure of representing bail bondsmen and insurance companies, Senator West, for that entire 40 years. I'm a member of the Professional Bondsmen of Texas. I'm on the board of directors. I also am one of the instructors in their continuing education class that's been mandated by Texas law since 2001. I've had the pleasure of representing bondsmen. I even worked in the bail bond office while I was going through law school, helped pay my tuition. I know this industry. I know these people. I know what they contribute to the criminal justice system. I'm in opposition to 1338, and I'm going to talk to you today shortly about the financial impact that we think 1338 is going to have on the criminal justice system. There are four primary areas I'm going to talk about. In Texas, every time a commercial bail bond is posted, a fee of $15 is tendered to the sheriff of the county where that bond is posted for each defendant. That excludes Class Cs. Of that $15, the county retains a 10% administrative fee. $10 of that fee goes to the Supplemental Prosecutors Fund, which is basically the longevity or retirement fund. $5 of that fee for every bond goes to the Fair Defense Act to help defer the cost to the counties of paying for criminal attorneys that are either court-appointed or public defenders to represent indigent defendants. So 1338 would mandate that primarily all misdemeanor bonds in Texas would be PR bonds. PR bonds generate no funds whatsoever. Let's go to the second category. Let me back up. Our research indicates that brings in annually $7 million to the state of Texas. Those bond posting fees alone. It was mandated by Texas law back in June of 2003. We estimate from figures from the Comptroller's Office that's close to or in excess of $100 million that's been paid into the state of Texas, just in posting fees. Those will not be collected on pretrial bonds. Second, court cost, another very significant amount. Every time there's a failure to appear, a bond forfeiture, the court enters what's called a judicial declaration of that forfeiture. That's called the judgment nisi or judgment nisi. That's the beginning of the state's petition against the bondsman in a civil court action. Civil court fees attach immediately to that document. They range anywhere from $300 to $400 per case throughout the state of Texas. Those fees for that court cost on that forfeiture are paid by the commercial bail bondsman every time that there's a forfeiture on a case, with few exceptions, whether they return the defendant to custody within the statutory time or whether it goes to full judgment. The figures that we have garnered estimate that that's roughly $3 million.
Sir, really, if you could just wrap up the final two
Sure.
with the numbers, because you're really, we're trying to keep.
Third and foremost is forfeitures. PR bonds are not collected. They're a promise to appear. It's a piece of paper saying the person says, I'm sorry, I'll show up. If they don't show up, there's no consequences. On a commercial bail, the bond forfeiture is collected by the county. It's a tremendous source of revenue. It totals, since 2003, over $325 million of revenue. 1338 is an unfunded mandate. It does not generate any funds. Ultimately will cost funds. Even though there's been an analysis by the state of Texas that there's very little cost to the state, that's passed on to the counties. The counties lose that revenue. Judges' salaries are partially funded by court costs in the state of Texas, roughly $41 for every case. All that revenue is lost. It's not being replaced by this bill. It generates nothing.
Senator Whitmire?
Briefly, how can you sit there and say there's no consequences to the person for not showing up?
On a pretrial release bond,
But you said there's no consequences, and that's not true. You know they file on you for failure to appear.
I agree with, well, in most jurisdictions they do
I'm
not.
just getting to a lot of your other facts.
Okay.
But the one that
I'll address it.
use as an example, we said under a PR bond, if you don't show up, there's no consequences. And you just know that's not correct.
no consequences in that individual having to worry about a private investigator being hired to go out and get him.
That person will have a new charge.
If he's
And a
caught.
warrant for their arrest will be issued.
That's true.
And it's the only ones that's going to get it are the low-risk people that have a job, a family, a house, the assessment of their risk factor. Just like it's working like a charm in Travis County.
I would disagree that it's working like a charm in Travis
It's
County.
working a hell of a lot better than about 15 misdemeanors sitting in the Harris County Jail tonight before they've gone to trial because they can't afford $1,000. Many of whom I would suggest are innocent. And all you've testified about is money, money, money.
Well, I'm a taxpayer. I am concerned about what this is going to cost the state of Texas.
Keeping people locked up and caring for them in jail when they could be back working, supporting their family, and agreeing to go to court would save taxpayers significant money.
And Senator, part of your bill addresses a very important issue, and I'll agree with you. But we don't need to throw the baby out with the bathwater. The system can be tweaked. It doesn't necessarily call for total abandonment of commercial bail. And in reality, that's exactly what will happen based on the model in New Jersey and other states that have adopted risk
If
assessment.
you look at the bill, that is still one of the choices a judge can make.
But it mandates so many requirements in order to hold somebody without risk assessment bail.
I think we put a real high value on liberty in this state.
We absolutely do, and the bondsmen provide that liberty to 99% of the people that are in
If they
custody.
got money.
You know, we talked about 10% fee that the bondsman charged. When I first started doing this in 1976, that's exactly what bondsmen charged. It's no different today. They also do credit bonding in the state of Texas. So competition and the free market system dictates that some of them do it for 5 or 6% or even less, and they let them pay it out. The person that's truly indigent, who absolutely is low risk and has no prior record, there is a system in place now where a judge can PR that person.
They don't do it.
Well, then we need to address the judiciary with instructions about using a tool that not only the Constitution allows, but the Code of Criminal Procedure allows. And that is, if somebody's sitting in a Harris County jail languishing for $1,000 who has no priors and commits a low-level offense, then we need to address it from the judicial standpoint that they need to be remagistrated, reconsidered, and given a reasonable bail or a bond reduction.
Right, any more questions from this gentleman? Okay, thank you very much to this panel for your contribution. We'll call up the last panel, Randall Sims, Rodney Bannerson. Okay, let's